Swayam Prabha. Digital India. Educated India.
Hello, my name is Professor Avinash Dadich and I am the Dean of Institute of Legal Studies and Research, GLA University, Mathura. In today's lecture, lecture number 15, we will talk about insolvency and bankruptcy law. Insolvency and bankruptcy, these are very classical words in our Indian culture. That you are insolvent now, and how this insolvency and bankruptcy provisions are important in law or in business. I give you very simple example so that you can understand the larger context. When you start working as a business manager or entrepreneur, you do a lot of transactions, and business is all about trust. That you give your product, someone gives you money, and this is how business is run. And cash flow management is very important, that money should come and money should go. Okay. Whenever this flow is restricted or disturbed, then the entire market can be disturbed. Like for example, if I give you product, okay, and you are supposed to give me 10 lakh rupees, fair enough. If you give me that 10 lakh rupees, then I will also give 8 lakh rupees to other people, like for example the vendors, suppliers, my employees and everyone, and then maybe 10 to 20% would be my profit. And then I will use that profit for my home, as well as I will use that money for reinvestment. Okay? And this is how we run our business. Now what happens, suppose if you do not give me that 10 lakh rupees, you have got some issues, some genuine issues, maybe real or fake, intentionally or unintentionally. At the end of the day, it does not matter. I am not getting my money back. So now those guys, all the 8 lakh rupees which they are supposed to get from me, now they are not able to get that money. So the vendor, the supplier, the raw material supplier, other service providers, my employees, so everyone will suffer. Then they will also become a defaulter. Once you become a defaulter, then I become defaulter, and then other people will become defaulter, and so. Okay. So this process can start from one person and it can affect many people's life, and ultimately it can affect the entire business. So what to do in this situation? Okay, I can file a case against you, and case will go on for 5 years, 10 years, 20 years. I am not getting my money. So if I am not getting my money, then what I will do with this litigation? And you are also incurring lot of cost. I am also incurring lot of cost. So everyone is suffering. In that scenario, the government of India has introduced a new type of solution. Insolvency and bankruptcy law was there in India earlier also, but in 2016 they introduced a new solution. That let us say if you are not able to give me 10 lakh rupees, then I must be able to go and say if you are not able to give me that money, you have become insolvent. You are not able to protect and respect your promises. So you have no right to run your company. In that scenario, the court, here the NCLT, we will talk more about, let us talk about a court for example, will introduce a new guy in that company, in your company, and that guy will manage the show. He will say, okay, now the overall liability on your company may be 1 crore rupees, you are not able to give them. So let us shut down your company, or we will run your company, but this is how we will repay the amount. So this entire process is very important for businesses, okay, So, I believe that after this lecture you will understand that how insolvency and bankruptcy law can be an opportunity as well as a threat for your company. Okay. So, business not just in India, but also around the world have time and again run into financial difficulties, which has led to closing of companies and selling of their assets of the company to pay the creditors. See, we need to protect the interest of creditors. Okay. So, it's very classical, it's not new one that people are closing their companies, they are selling their assets, just to repay their debts. So, this is very classical situation. The closing of a company has many economic implications, as it leads to loss of jobs, also it diminishes the earning capacity of the country at large. So, if you shut down your company, then not only creditors suffer, but people lose their job, and ultimately this is a national tragedy. Okay. We do not want that people should shut down their companies. There has to be some solution, sometime intentionally, unintentionally, or due to market situations you are stuck somewhere. Okay. So, once you are stuck somewhere you need a solution, and maybe because of the court litigation both parties are fighting with each other. So, they are maybe not able to find a workable solution. So, this law gives them a workable solution. Therefore, to prevent the closing down of business, many countries have made serious efforts to formulate certain laws and regulations to help the failing company to stand on its feet and recover from heavy debts. What we want? We do not want that people should close their companies. Yes, we do understand now they are in bad situation, their finance situation is not good, they have heavy debts, but at the same time we want that they should recover. Okay, because once they recover, this is good for everyone, for their employees, for their vendors, for their creditors, and even for the government, because if someone is dead you can't get anything, a dead person can't create anything. So, what we want that the sick companies, the companies facing some financial difficulties, they must be able to recover. Okay. So, this is like in a new type of approach that do not kill the company, just find a solution. On the same line of thought, the Indian legislature also enacted the Insolvency and Bankruptcy Code in order to help those companies who are in debts and are unable to pay the creditors. So, same approach that we want to help both. It is not only creditors, but we want to help the debitors also. What we want that both parties, because it is not only as I said, it is not only the companies or the promoters, it is a big chain, the employees, vendors, suppliers, so many people are depending on business. Okay. So, we want to help all of them. The idea behind the code was to provide a rescue mechanism to the companies, so that they can recover fast and again become a wheel in the economic progress of the company. So, it is a rescue mission, it is not killing mission, it is not killing objective that let us kill someone. See, when you go to a courtroom, like normal courtroom, court says okay, we really do not care about your business, you have to pay this money, if you can't pay this money we will attach your property and we will do this, that, somehow you have to pay. Okay. The court is not designed to understand the business and economic aspects of any company. The court will do only legal analysis, that legally if you are supposed to pay, you pay. We really do not care about your financial situation, we do not care about your economic situation, the market situation. Like for example, this during the corona period, if you go to a courtroom and say okay, this guy is not paying my money, the court will examine the documents and say okay, after examining the documents, after maybe a very lengthy litigation, and they say okay, as per the contract you are supposed to pay, so you pay. We really do not care about corona or maybe some problem happened in the market, So, sometimes the courts are not the right solution for the business problems. Moreover, the Act also provides easy exit option to those countries who have reached to a stage from where recovery is not possible and closing down the business is the best available option. So, it is, see, sometimes exit option is also required. You want to quit because you know that it cannot recover, you know it, everybody know that it's impossible, you know. So, instead of putting too much more money and more resources, more effort just to make it live, sometimes it is good to exit, you know. So, whatever you have right now, like for example, if I give a simple example, see, I am trying to give you simple explanations instead of very complicated legal understanding. Suppose you have a company, your assets are maybe 100 crore rupees. Now, due to some business failure, some market situations, and X, Y, Z, many factors are there to fail a business. So, your overall debts are now 500 crore rupees, and you know that business is not happening and there is no way that you can continue with these 500 crore rupees debts. Okay. So, now there are two options, either we use the first option that we try to recover you, but the market is such that there is no possibility. Okay. With this finance accounting rules, there is 0% possibility that you can recover. So, now what we can do, first option, go to the court, file the case, fight for 5 years, 10 years, 15 years, and meanwhile business is not happening. So, your assets are losing their value, like for example machines. If production is not happening, what will happen with the machines? Right now maybe the value is 50 crore rupees, but after 10 years maybe nobody is ready to take them even for 1 crore rupees. Okay. So, this is very important, this is very important to understand. This is very important to understand that if you exit at right moment, maybe you can get the right price, and then if you are able to get 100 crore rupees at one particular point, maybe you can pay 20% of your debts, maybe not 100%, but 20%. Now, maybe your question is, sir, this is injustice for the people who have losing their money, but then my argument is that after 10 years, 15 years, if the value of that company assets will go down to 10 crore rupees, then what will happen with the debtors? Right now they are able to get 20%, maybe after 10 years they will get only 1%, and even after lengthy litigation they are putting more and more money on lawyers, litigation, law firms. Okay. And 1 rupee is better if you get today rather than 2 rupees you get after 15 years, because you can use that 1 rupee immediately. So, these are the philosophies of insolvency and bankruptcy law. So, sometimes exit option is also good. Therefore, this PPT or this lecture will focus on intricacies involved in IBC, and also try to explain the technical terms they are being used frequently in the code. So, insolvency and bankruptcy are the same. Let us see. Insolvency means the inability of the business entity to pay off its debts which it owns, that is an insolvency. Okay. It can be further classified into two types. One is where the company assets are not sufficient enough to completely pay off the debts of the company. Like for example, if all the assets are sold, then also the debt will not be fully paid. Like just I said ki 100 crore rupees assets value, debts are 500 crore. So, even if you sell the entire thing, you will not be able to pay 500. Second is the day to day inability to pay off any debt as it falls due. The company does not have enough cash in hand to pay any kind of debt that may arise in the day to day functioning of the company. Sometimes it is not about the assets, maybe they have more than 1000 crore rupees assets. Okay. But for the day to day management, like suppose every month you have to pay 50 crore rupees, So, you do not have that 50 crore rupees in cash every month to pay your debts. I hope you are very clear. In one situation your assets are not enough, so you can't pay. Second, we are not talking about assets, maybe you have assets 1000 crore, but your day to day financial cash flow is not enough to pay your debts. Okay. In that situation, the company is unable to respect its liabilities. Bankruptcy. Bankruptcy is a step ahead of insolvency. It is a legal declaration by the court of one inability to pay debt. So, basic difference is in insolvency the business itself declared that they are unable to pay debts. However, when the same gets sanctioned from the court, then it becomes bankrupt. Okay. Moreover, bankruptcy is that legal process through which people or other entities who cannot repay debts to creditors may seek relief from some or all of their debts. Therefore, when an organization is unable to honor its financial obligations or make payment to its creditors, then in such case it file for bankruptcy. In both situations, I do not have money, but the fine difference is that in insolvency either your assets are not sufficient or your cash flow is not sufficient. So, you declare that sorry I can't pay, like so for example, I am in this situation, I will say okay sorry I can't pay, my cash flow is very less, I am making only 7 crore rupees cash flow every month. So, how can I pay 20 crore rupees every month? This is impossible for me, So, please I want to declare myself as an insolvent. Okay. In bankruptcy situation is different. Here the creditors are going to courtroom or they are going to the concerned authorities and say this guy is not paying us our debts. Okay. For example, suppose the monthly requirement is 20 crore rupees. Okay. Maybe your cash flow is 17, 18. So, you are not sure like to whom I should pay. Okay. So, you are paying sometime to this guy, sometime that guy, and you are using some money for your home, some for reinvestment, so many things are happening. So, even you are not sure whether you are insolvent or not, you are trying your best, In that scenario, the parties cannot wait to you become insolvent. So, they can go to the court and say, okay, please declare him bankrupt. He is not able to respect or honor his financial obligations. In that scenario, please declare him is bankrupt and ensure that we get our money back. Okay. I hope that now you are clear the distinction between insolvency and bankruptcy. Liquidation. After bankruptcy, if the firm is unable to recover and still in debt, the next stage that the company follows is to go to the liquidation. Liquidation is formally the process of closing a business so that its assets can be sold to pay its debts. To liquidate a company is to close it down or sell all its assets, usually because it could not repay the debts. So, what will happen? The first thing insolvent, second is bankruptcy, and third is liquidation. Liquidation means that now the court will appoint someone and that guy will start the liquidation process. They say okay, you can't pay, so what we will do, we will sell your entire company and whatever money we will receive, we will pay to creditors. And why court appoint someone? Because if I give the same task to that person, the real owner of that company, there is a possibility that the money can go from here and there. Okay. He can do maybe something which is not acceptable, which is not good for creditors. In that scenario, the court appoints the person who does this activity. So, legal framework that existed prior to IBC. So, what was the legal situation before the IBC? Prior to IBC, there were many laws in India that dealt with aspect of repayment of debt in India. Okay. All the acts had one or other provisions or authority that had an important role to play in debt repayment or closing down the company. So, this is not like a new situation, as I told you, people were losing their money earlier, companies were shutting down. So, this is very old situation. So, before IBC there were few laws. So, this is like a Sikh Industrial Companies Special Provision Act 1985. The act was enacted with the objective of timely detention and revival of Sikh industries companies. So, Board of Industries and Financial Reconstruction and Appellate Authority for Industrial and Financial Reconstruction were formed under this act. but the act had many loopholes which were creating issues in timely resolution of debts in companies. So, basically they were trying to restructure the financial situation of the company, but it was not working. Frankly speaking, it was very lengthy, inefficient process, and ultimately nobody was winning in this case. Then Recovery of Debt Act 1993, then Sarfazi Act introduced by RBI, schemes and mechanism introduced by RBI for restructuring of non-performing assets. It talked about out of court process, but lacked the legal sanction. Okay. And then there was some old laws also, like the Companies Act. They also have provision that if someone is not able to repay his debts, then you can go for the winding up of the company, that this company should be shut down on the ground of inability to pay debts, okay, inter alia. So, you need to understand that these provisions were earlier present in the laws. It is not like that this is the first time the government is trying to create a legal framework. The only issue that all these provisions were here and there was no consistency. So, people moved in different types of litigation, different forums like the company board, civil court, criminal court, high court, and so much chaos. Okay. So, it was very difficult to find out a right solution, organized, efficient solution. Then there was another law, Presidency Town Insolvency Act 1909 and Provisional Insolvency Act 1920. These were the earliest law that deals with insolvency of individuals and partnership. It also provided for filing of the application. So, during the British period we also had insolvency law. However, with the growth of business, the provision proved to be obstacle and no help in the present situation. So, these laws were not helping the business. And then why we enacted a new code? Reasons are very simple. If you see the time in years, time taken to resolve insolvency. So, then if you see Singapore 0.8 years, like 8 months, USA 1 year, UK 1 year, China 1.7, South Africa 2.0 and India 4.3. Okay. So, in 2016 it was 4.3, it means almost 4 to 5 times compared to Singapore and USA and UK, and came down to 1.6 in year 2019. So, now you can see very clearly that if it takes too much time, like all the old laws, they were there, but the time taken, average time, again I say it is an average time, So, in some cases maybe it goes to 6 years, 7 years, 8 years. What will you do after 8 years? If you lose your money, if you lose your assets after 8 years, there is no one use that capital. Then if you see ease of doing business ranking, World Bank 2015 reports. So, these reports are issued by the World Bank every year and talks about ease of doing business in a particular country. So, in this particular manner, the insolvency thing, Singapore was number 1 and USA number 7, UK 8 and India was 142 in 2015. Okay. It was very difficult to recover money in India, and our ranking out of 189 nations, 142. That is not good for any mature jurisdictions like India, mature economy like India. And finally, in 2020 it came down to 63. So, you can see very clearly 142 to 63. So, the impact of this insolvency and bankruptcy law can be easily seen through this chart, that from 4.3 years to 1.6 years, then 142 ranking to 63 ranking. And problems and reasons to failure of these laws. Why the law failed? The current state of bankruptcy process for firm is highly fragmented framework. As I said earlier, fragmented everywhere. So, ultimately you do not get any answer. After 7, 8 years, 9 years, 10 years, you get an answer, and by that time there is no use of debt capital or resources. You want quick solution, you want that If I want to exit from this business, I should be able to exit in 1 year, 1.5 year. Then I can use some of the resources and do something else. Okay. Same thing for creditors. If I can get my 20, 30, 40% money right now instead of 10 years, 15 years, then I can use that money. Powers of creditors and debtors under insolvency law are provided for under different acts. So, even the powers and the responsibilities, see, it was completely mismatch. One law was saying X, other law was saying Y, and completely mismatch. And multiplicity of forums under various laws resulting in lack of clarity for jurisdiction. In a situation where one forum decides on matters relating to the rights of the creditors, while another decides on the relating to the rights of the debtor, the decisions are easily appealed against the either state or overturned in a higher court. So, it was like one court, another court giving different judgments, people were appealing in the high court, and now you can easily see when so many litigations are happening at different level, it can create only chaos, it can create only confusion. Due to delay in resolution because of the loopholes in the previous legislatures, a need was felt to have a consolidate law, consolidate like one law that can be used to provide a viable solution for companies and creditors. Okay. So, the forum entrusted with adjudicating on matters relating to insolvency and bankruptcy were regular forum, and the people sitting in those forums might not have the expertise. This is again very important, expertise, to have financial expertise. They must understand the nitty-gritties of business. If you ask a normal judge who is hearing civil, criminal, family, all types of disputes, and suddenly you ask that judge to deal with very complicated financial transactions, business transactions, market realities, it is difficult for that judge to even decide, to understand and appreciate. So, we need a forum where the judges are very much expert, and there should be a panel of judges, not only one judge. So, one guy can be expert in business, other guy can be expert in law, and the other judge can be expert in finance or accounting. So, this is how we can create a mechanism where the courts can give business friendly solutions. As a business student, you need to understand that they need business friendly solutions. It is not against one person or favoring one person, ultimately everybody should be a winner. My dear students, the only contracts or agreements or any system survive when both parties are winner. Okay. Even if one party is loser, that contract will not survive for a longer period, that system will not survive for a longer period. So, in that scenario, suppose if I am the debtor, if I have lost my money, I have lost my company, but after repaying all the debts, now I have no debts, I am absolutely clear, I lost my company like 500 crore rupees debts, 100 crore rupees assets, and I said, okay, please sell all of my assets and make me free. Okay. So, after this process, I can go back and start a new business. Okay. And I do not want to hit again the same wall, because that will not bring any outcome. So, this is good for me and win situation for me, and it is a win situation for creditor, because right now within 1 year, 1.5 year, that creditor will receive some money, and he will not invest more money on litigation and disputes. Okay. And whatever money he receives, that will be transparent, there will be no game, and whatever he receives quickly, he can use it for his business. Okay. So, at least he can mitigate his losses. And students, you need to understand, in business certainty is very important. If I know that today I am going to get 20 crore and through this deal I will lose 30 crore, like total was 50, I am getting only 20. So, 30 crore is my loss, that is fine. If I know it today, that is better for me. The problem is that if I know that after 5 years, 10 years, 15 years, I really do not know how much money I am going to lose, how much money I am going to get, this uncertainty is not good for any business. Okay? And why code and not an act? So, a code consolidates laws relating under one umbrella, providing compilation of rules, regulations and laws. Act normally are standalone, the Contract Act, Sales Good Act, but if you put them in one umbrella where different laws, different acts are working all together to find a common solution. A code of law is a type of legislature that purports the complete system. You understand? Because as we seen earlier that when you have different laws, different places, different forums, then it creates uncertainty. So, code creates a certain mechanism, while an act is a piece of legislature where is the base of forming a law. The Insolvency and Bankruptcy Code 2016 is a code and not an act. A unified code to deal with the insolvency law in India, which covers every aspect of the legislature. So, now see the object and purpose of the Insolvency Code: to consolidate and amend the law relating to insolvency and corporate persons, partnership firms and individuals in a time bound manner. Students, the second thing which is very important for any business is time. The first thing, as I said, certainty, that what is going to happen. If I know today, I am okay, I can integrate that loss, profit, financial situation into my books, and then I can make my strategy. Okay. Now, you please try to understand this insolvency law from business perspective. Okay. So, as a business person, if you know that what is the situation, good or bad, you can integrate in your strategy, in your planning. Okay. Uncertainty is a problem. Second, after certainty, you want time bound process. Time bound process means that you should know exactly that how much time it will take. If I tell you, okay, you will get 5 crore rupees, or I will tell you get 100 crore rupees, that is fine. But if I say I really do not know when, maybe 2 years, 5 years, 10 years, 15 years, that is a problem for business, because as a business person you want time framework also. Certainty, how much, and time, when. So, maximization of the value of assets. So, you do not want that asset should lose that value with the time. To promote entrepreneurship, so you must be able to take some risk. If you start a business, if you lose a business, you want to exit, you do not want to involve in too much litigations. So, if you want to become an entrepreneur, you need an environment where you can exit also quickly. To establish an Insolvency Board of India, to designate the NCLT, National Company Law Tribunal, and DRT, Debt Recovery Tribunal, as adjudicating body in the insolvency proceedings. To separate the commercial aspects of insolvency and bankruptcy from the judicial aspect. So, sometimes commercial and judicial, when I say judicial means legal, you do not want to mix them too much. So, sometimes you want a mechanism where law and business, they are dealt differently. Okay. Key achievements of the code, what we have achieved through this code. I think I have already given you some numbers. You can easily see that within 3 years, 3 to 4 years, we have achieved a lot, and it is not the government of India's data, it is a World Bank data. So, it is very much clear that now our country is not seen as a defaulter's paradise. Earlier the image was, and still it is like I must say, because this is a new law, it will take some time, but still people believe that if you do not pay someone's money, nothing is going to happen. No, that is not the situation anymore. If you do not pay your money, if you are a defaulter, it is not a paradise for anymore, it is a hell. Okay. People will go and ask directly to the NCLT that please declare him bankrupt. Okay. Suppose if I am a very big businessman, very big businessman, and if I do not want to pay you your money, like suppose if I am a very big businessman, I have lot of money, but this is how I have done my business that I do not pay you money. Like suppose you supplied me suppose 5 crore rupees raw material, So, my strategy is that I do not pay you, I am such a big businessman. So, maybe first 2 transaction I give you 100%, but after third and fourth transaction I do not pay you. I say okay, I do not have money, though I have money, because I know that I am a big guy, and if you want to go to the court, let us go to the court. I do not mind, I will pay maybe 5-10 lakh rupees to my lawyers and they will fight for me. Then we will negotiate, and I will you will say okay sir, if you can't pay me 5 crore, can you pay me 2 crore? I say okay, 2 crore is fine, take 2 crore and go away. So, this is how I run my business. I am sorry to say this was and still this is quite common in India, but now because of insolvency and bankruptcy code, you won't negotiate with me. You say okay, you do not want to pay me, that is fine, I am going to NCLT and I will make a request before the NCLT that please declare this company, this big guy, as a bankrupt. Okay? If he cannot pay the money, he should not run his business. So, now this defaulters paradise approach or the image of this country is changing. Provided easy access to the corporations, that is very important. Sometimes you are a good guy, you want to continue, but you are not able to continue. So, instead of killing you or filing more and more cases against you, everybody knows that you are not going to, you have no capability to pay. So, instead of harassing you and putting more and more cases, involved in too much litigation, why we cannot create a system where people can exit peacefully? Okay. Help in improving India's rank in ease of doing business ranking from 142 to 63. So, that is a big number. Transfer the resolution process in the hands of body of experts. Okay. This is very important. Earlier the government officers or maybe the judges, they were involved, they were doing this job. Now, the experts, the real business experts are doing it. The judicial interference in resolution process has been reduced, still is there, high courts and supreme court still they are there, but they do not interfere in day to day process. Directed to bring the corporate debtors, the company who are in debts, back on its feet and not mere recovery legislature for creditors. So, even if you are a big guy, that does not matter. Like Anil Ambani, it is a very simple example. Okay. Anil Ambani was declared bankrupt. Okay. So, this is very simple. It really does not matter whether you are a small guy or big guy. If you are not able to pay your loan, if you are not able to pay your, if you are not able to respect your financial obligations, you have no legal right to do business. Okay. As simple as that. Interest of corporate debtors bifurcated from the interest of promoters. This is very important. Sometimes promoters, the people who are the real owners, and the company. So, sometimes they have vested interest, the promoters, they want to take more and more money. In this case, it will be stopped. Inefficient promoters and management barred from regaining the control of corporate debtors. Object at bringing the corporate debtor back on the track. Liquidation has been suggested as the last resort. Okay. So, what they want, that the idea is that the company should run, company should run, we should try to find a solution. Suppose if we believe that the owners, promoters, they are inefficient, we can remove them, we can put some official, well educated, trained MBAs like you, suppose you are an MBA, you are, so maybe they can appoint you as a CEO of that company and you can run that company. Okay. And liquidation process, like liquidation means like selling off the entire company and asset, is like the last option. Okay. It's not, this is not the first option, this is the last option. Management of company transfer in the hands of expert professional during the resolution process. So, during this process, the promoters, board, they have nothing to say. Now, the expert people are running the show. Provides for the provision to deal with concealment, frauds and manipulation. Okay. So, if the promoters or the board of management, if they are trying to conceal something, if they are doing some fraud or manipulation, there are some provisions to deal with those situations also. So, this is the scheme of act. You can see easily chapter 1, chapter 2 corporate insolvency resolution process, liquidation process, fast track corporate insolvency resolution process, voluntary liquidation. So, you can see easily, it is a very clearly, and chapter 7 talks about offences and penalties. Then part 4, regulation of insolvency professional agencies and information utilities. Okay. So, what triggers an insolvency when it starts? The insolvency codes get triggered when the company, the corporate debtor, is unable to pay off its debt to the creditors, and the creditors approach the adjudicating authority, NCLT, National Company Law Tribunal. And you need to understand, NCLT is not only in Delhi. Now they have more than 25 branches in India. So almost they are in every state. So if a company is not paying the debt, then you can approach to your local branch. If you are, suppose in any state you can go and file a case. NCLT via an application which includes a demand notice stating the amount that is due to be paid. So first the NCLT says, okay, please give the amount. If you are not able to pay, then we will start the process. Pillars of IBC: Insolvency and Bankruptcy Board of India. Okay, this is the unique regulator constituted under the code, which regulates the professional as well as the process under the code. Insolvency professional, so you can also become an insolvency professional. So they are the people who are treated as an experts. These insolvency professionals are private professionals having enough education, professional standards and ethical under the supervision of the board. Insolvency professional agencies and adjudicating authorities like the NCLT. Okay. And in the case of individual and partnership firms, the debt recovery tribunal. So this is the process, you can see very easily. Filing of application in the NCLT, you file the application, then they announce in the public, appointment of insolvency professional, declaration, then invitation of claims, then constitution of committee of creditors, then appointment of RP, then invitation of interest and issuance of IM, information memorandum, submission of resolution plans to RP, approval of plan by COC, and acceptance rejection plans by NCLT. So this is very clear, very smooth process, and we will see the timeline now, how it happens, when it happens. So important cases, now we will deal with some important cases. So the first is JK Jute Mills Company Limited versus Surendra Trading Company. So in this case, it was decided by the Supreme Court that 14 days for the AA to admit or reject an application, 7 days of an applicant to rectify. So they have given the timelines basically. So the timeline for 14 and 30 days are directory in nature, while those are 7 and 180 days are mandatory under the code. So time frame is well defined in insolvency and bankruptcy code. So if you read this law, you will understand that time is very, very important. Time is the crux. Okay. Proceeding under the code are not necessarily adversarial. So in this case, the adjudicating authority observed that apparent reading of the code will reveal that it is not an adversarial proceeding. Prevalence of the democratic system ensure that all the adjudicating authority cannot hang on or in conventional approach that the legal proceedings shall be adversarial. Okay. So this is very clear that this is not like a hard remedy, this is nothing against one person. You need to understand, the court decides that you are right, you are wrong. In this case, insolvency and professional board, they do not want to decide that you are right or you are wrong, they are just trying to find a business solution. Okay. Rule of principle of natural justice. So in this case, Calcutta High Court observed that the requirement of NCLT and NCLT to adhere to the principle of natural justice to be determined. Okay. So principle of natural justice, as we discussed earlier, that principle, that right to be heard, that no one can take a decision without giving an opportunity, there should not be any bias, there should be a fairness. So all these principles they have to follow. It also held that NCLT is obliged to afford a reasonable opportunity to the financial debtors, and it may do so prior to admitting the petition filed under section 7. So they have to give a reasonable time to debtor, they cannot say, okay, now in 5 days you pay your debts. They have to give them reasonable time, reasonable opportunity. Okay. And then another case, Section 424 of the Companies Act requires the NCLT and NCLT to adhere the principle of natural justice. This is very clear. Held, it is mandatory duty of the adjudicating authority to issue notice before admitting application of CIRP under section 9 of the code. So, without giving them opportunity to be heard, they should not decide anything. Dispute and existence of dispute under section 5 subclause 6 of the code. In this case, it was held that whether notice of dispute in fact raised the dispute, and that too within the parameters of two definition, that and default. Okay. So, it was decided that in another case, Construction Company Limited, definition of dispute under section 5 subclause 6 of the code held to be illustrative 1. Okay. So, guys, this was about the insolvency and professional bankruptcy code, and my hypothesis and my reasoning is that people are doing business for profit. You will be working as a manager, eventually you will become a senior manager, or maybe you will become an entrepreneur. So, you are doing business for profit, all parties are doing for profit, but sometime due to unintentional, uncontrolled situation in the market, people are not able to repay their debts. Okay. I hope you are understanding this point. They are not able to repay their debts, therefore, it is very difficult for them to continue in business. Now, the question arises, should we kick them off from the market? Should we create a situation where people do not even dare to become an entrepreneur or business person? So, the business, running a business should not be a taboo. Okay. I think in last 50, 60, 70 years, what the society we have created, that if you are running a business, if you make money, then everybody will come to take the part, like the government will come for the taxes, people will come for jobs, and everybody wants to party with you. Party means like everybody wants to have some share with you. But if something goes wrong with your business, then the entire blame is on you. Then they say, okay, you lose your business, now you suffer. But is it fair? This is not fair system. So, that is the one part. Obviously, there are some other part also. There are some unintentional delays, some bad faith, people, wrong people, corrupt people, greedy people, manipulative people. So, there are two types of business people, one, honest people, hard working people, they want to do their business with honesty. Sometimes they lose money, sometimes they lose their business due to some uncontrollable situations, like during the corona. Like for example, if you suppose you just started a factory, for example, if I give you one example, in December 2019 you launched a factory. Okay. You took lot of loan, and then you took lot of raw material on credit, and you say, okay, I will pay you in March, like please give me 3 months time and I will pay you in March. And you start doing your production, and by 20th of March suddenly everything is stopped. Now, there is no buyer, and you have your stuff with you, you have got your orders, but there is no way that you can supply them, there is no transport facility, and eventually your all orders got cancelled. Okay. You thought that I will get my money from 20th March till 31st of March, and 1st of April I will pay you. I will pay my people, but on 20th of March everything stopped. Now, you can't pay anyone, your orders are lying in your factory, there are no workers for you, everybody has gone their home. Now, in that situation, what we should do? First option, that whatever you have invested, people should go to the courtroom, they say, okay, we want our money back and we really do not care what happened with this guy. Second approach could be that, yes, let us go to NCLT, try to find a solution. And the NCLT guy says, okay, we do understand, we appoint a professional person, he will sit with you, he will try to find a solution, and then in this process, if we can help him, this person, for 3 to 6 months, then maybe he can run his business again, and then eventually you get your money back. Okay. Or second option, that maybe he can pay you right now 20% amount, and remaining 80% amount you get after 1 year. So there are so many options, there are so many opportunities for both parties. In that scenario, that person can get some time, some fresh air, fresh opportunity, and run his business again. And when things get normal after the corona thing, employees can come back, laborers can come back, they can start their job, and then all parties are happy. So that is one situation. This is the involvement, this is the positive side of insolvency and bankruptcy law for honest people, okay, honest businessmen. So law is not only, as I said, this law is not about adversarial, it is not about right or wrong, it is about finding right solution. So in one situation the honest people are saved. Now there is another situation, that I am running my business and I do not want to pay people. Simple, this is my business strategy, that I always like to take money from them, but I do not want to pay them. In that situation, now there are, suppose in the absence of insolvency and bankruptcy code, that person owns maybe 20 crore from you, and you say this is unfair, at least you should give me 15 crore. He said, no, I really do not want to pay you even a single penny. You go to the court, and in courtroom we will fight with you for next 10, 15, 20 years. This, as you know, this is like how Indian courts are working. And then during that 10, 15, 20 years, you invest maybe another 1 crore rupees on your lawyer's fees. Okay. And after 20 years, that guy pays you maybe 10 crore, 15 crore rupees. Okay. So he is the winner, but you are the loser. And not only you are the loser, all the people who are associated with you, because I said earlier that when one person loses, so many people loses after him. So when you are not getting your money, your people, employees, your supplier, your vendors, they are also losing. In that scenario, the insolvency and bankruptcy law can help you. Like you can go before the NCLT and say, this company is not paying me, please help me. Then the expert will come and he will try to assess the situation and will ask a very practical question to this guy. When you have resources, when you have money, why you are not paying him? Because right now you are not able to access his bank accounts. You really do not know whether he got the money or not. But once the professional person is appointed by NCLT, he can assess his accounts book, he can assess his bank account and everything. Then he will ask a very practical question, why you are not paying him? You have got money, okay, so pay him, first thing. Suppose he does not have that much money and he say, okay, if you do not have much money, are you ready to find a solution? If you are not ready to find a solution, we will do the liquidation process. The liquidation process, we will sell off your company and we will give money to creditors. So guys, insolvency and bankruptcy law is going to become very important. Right now it is not introduced for partnership firms, individual firms, LLPs, but very soon I believe that after this corona it will be introduced for partnership firms also, individuals also. Even if an individual person is not paying the money, suppose if someone is doing business, not a company, as an individual business or a partnership firm, then you do not need to go to a civil court, you just go to the NCLT and go for the application. So what I believe that as a business person, as a business manager, if you use insolvency and bankruptcy for the right purpose, in good time or in bad time, both, this law can help you to minimize your risk, minimize your business risk, and can provide lot of business solutions, and it also promotes entrepreneurship. So if you want to start a new business, this law can help you, So if even if you lose, you do not lose everything in your life, you lose only one part of your business and then you exit and you do some another business. So I was talking about entrepreneurship, obviously now you are very clear about the companies, But how the insolvency and bankruptcy can help you to become a good entrepreneur? See, whenever you want to become an entrepreneur, you are taking a risk that what if you lose, what if your company doesn't work. So, in that scenario, you want to minimize, you want to fix your liabilities. Like for example, if I say that I am launching my startup and my liabilities should not affect my personal life or my family life, my family property, my personal property. So, you create an LLP type of model. Okay. But then if you are not able to repay your debts, people start filing cases against you, and then after 5 years, 10 years going to courtroom, in civil court, criminal court, DRT, then high court, you are absolutely destroyed. So, you lose your business, that is a very great disaster, but after losing your business, instead of focusing your energy on some another business, you are moving around with so many litigations. Okay. So, that is a deterrence effect on the entrepreneurship. When you see that other entrepreneurs are facing the same situation, you do not want to start your new company. So, this insolvency and bankruptcy law can help you. It says, okay, you do your business with honesty, you keep your documents very clean, and after some efforts, with your best efforts, if you are not able to repay your debts, okay, then please go to the NCLT and declare yourself bankrupt. And bankruptcy is not a bad word. Maybe in Indian context bankruptcy is a bad word, but you need to understand the former president of United States, Donald Trump, he declared himself bankrupt many times in his life. So, you declared yourself as a bankrupt only for that particular startup. You are not, it is not the end of your life. This is just like end of that particular company or that particular startup. You finish it there, then you move on. You move on, you start a new business. Okay. So, and for the entrepreneurship, easy entry and easy exit, both are important. So, this insolvency and bankruptcy law can help you for exit, smooth exit also, without any humiliation. Whatever you have in your company, that will be sold, and whatever money they receive, not you, the professional person, whatever money he receives, he will give that money to creditors, matter is off, no further litigation against you. So, what I believe that this law really can help you in doing business, entrepreneurship, and when you join a company, whenever you see this situation and if you believe that things are getting out of control, you can give advice to your bosses, your seniors, that sir, there is an insolvency and bankruptcy law, can we use it? Okay. So, with these words, I wish you good luck for your professional career and for your entrepreneurship career. Thank you very much.